All rise. Veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Veuillez vous asseoir.
Thank you, Mr. President. The situation in the Central African Republic, in the case of the prosecutor versus Jean-Pierre Bemba Gombo, Aimé Kilolo Musamba, Jean-Jacques Magenda Kabongo, Fidel Babala Wandu, and Narcisse Arido. Case reference, ICC 0105-0113. For the record, we are in open session.
Trial Chamber 7 of the International Criminal Court hereby delivers a summary of today's judgment as to whether Mr. Jean-Pierre Bemba Gombo, Mr. Bemba, Mr. Aimé Kilolo Musamba, Mr. Kilolo, Mr. Jean-Jacques Mangenda Kabongo, Mr. Mangenda, Mr. Fidel Babala Wandu, Mr. Babala, and Mr. Narcisse Arido, Mr. Arido, are guilty of having committed offenses against the administration of justice involving 14 witnesses who had testified on behalf of the defense in the case of the prosecutor versus Jean-Pierre Bemba Gombo, the so-called main case. The Chamber underscores that only the written judgment in English is authoritative. May I first please ask the parties to introduce themselves. Madam Prosecutor.
Thank you, Mr. President. Mr. President, honorable judges, the Office of the Prosecutor is represented today by Mr. Kweku Van der Puy, Senior Trial Lawyer, Oliver Struven, Trial Lawyer, Hesham Murad, Trial Lawyer, Ruth Frolick, Trial Lawyer, Nema Milaninia, Trial Lawyer, Ms. Silva Wakcham, Assistant Trial Lawyer, Ms. Esther Kosova, Assistant Legal Officer, Ms. Sylvie Vindinya, Case Manager, and Ms. Mary Alvin Chakanda, Associate International Cooperation Advisor, and myself, Fatou Bensouda, Prosecutor.
Thank you very much. We turn now to the defense. Perhaps we start with the defense for Mr. Kilolo.
Bonjour Monsieur le Président, bonjour Messieurs les juges. Maître Aimé Kilolo Musamba est assisté par Mademoiselle Rosalie Mbenk, case manager, Mademoiselle Groga Loïka, avocate au barreau de New York, case manager, Maître Stephen Pauls, avocat au barreau de Londres, conseil associé, et moi-même, Maître Paul Djunga, avocat au barreau de Paris, conseil principal.
Thank you very much. The defense for Mr. Arido, please.
May I please your honors? My name is Chief Charles Achaleke Taku. I'm counsel for Mr. Arido. I'm assisted today by Mr. Tassis Gatarama and Mr. Mike Rao, and my colleague Beth Lyons is not able to be here today, your honors. Thank you so much.
Thank you very much. The defense for Mr. Mangenda.
Good afternoon, Mr. President. Good afternoon, Your Honors. Christopher Gosnell and Nikki Sethi for Mr. Mangenda. Thank you.
Thank you. The defense for Mr. Babala.
Bonjour, Monsieur le Président. La défense de M. Babala se compose ce jour de deux gestionnaires de dossiers, Coralie Klipfel, Maria Adriana Manolescu, d'un assistant juridique, M. Godefroy Bokolombe, et de 2 avocats, Maître Azama Chali-Rodoma, avocat au barreau de Bruxelles, conseil associé, et moi-même, Jean-Pierre Kilenda Kakengi-Basila, avocat au barreau de Bruxelles, de Kinshasa-Gombe, conseil principal.
Thank you very much. And finally, the defense for Mr. Bemba.
Good afternoon, Mr. President, Your Honours. Mr. Jean-Pierre Bemba is represented today by Ms. Ines Pierre de la Brière, Ms. Stephanie Schilders, Ms. Eugene Liu, and myself, Melinda Taylor. Thank you.
Thank you very much. Before I read out a summary of the main findings of the Chamber and finally the verdict, please allow me some preliminary remarks. This case was about offenses against an administration of justice, as Article 70 of the Rome Statute puts it. This means it was about giving false testimony, presenting false evidence, and corruptly influencing witnesses. Although such offenses are not the core crimes this court was established to try, it has become apparent in the short time span of the court's existence that preventing offenses against the administration of justice is of the utmost importance for the functioning of the International Criminal Court. Such offenses have this significance because criminal interference with witnesses may impede the discovery of the truth in cases involving genocide, crimes against humanity, and war crimes. They have this significance because they may impede justice to victims of the most atrocious crimes. And ultimately, they may impede the court's ability to fulfill its mandate. Turning to the judgment, the Chamber is satisfied beyond reasonable doubt that the accused committed offenses against the administration of justice in this case. Mr. Bemba, Mr. Kilolo, and Mr. Mangenda jointly agreed to illicitly interfere with defense witnesses in order to ensure that they would provide evidence in favor of Mr. Bemba. This common plan was made in the course of the main case between the 3 accused and involved the corrupt influencing of at least 14 main case defense witnesses together with the false presentation of aspects of their evidence. Mr. Bemba, Mr. Kilolo, and Mr. Mangenda adopted a series of measures with a view to concealing their illicit activities, such as the abuse of the registry's privileged telephone line in the ICC detention center, or money transfers to defense witnesses through third persons, or to persons close to the defense witnesses so as to avoid detection. Mr. Kilolo, assisted by Mr. Mangenda, secretly distributed new telephones to defense witnesses without the knowledge of the registry so that Mr. Kilolo could stay in contact with them. They also used coded language when speaking on the telephone, making reference to persons by using acronyms or using particular expressions such as the term faire la couleur or variants thereof, signifying the bribing or illicit coaching of witnesses. As Mr. Kilolo confirmed one day to Mr. Mangenda, complaining about the performance of one witness, quote, "Now you can see the problem. I've always told the client to redo the color a day or 2 before the person appears. Why? Because people forget. You see, people don't remember at all accurately," unquote. Mr. Bemba, as the ultimate beneficiary of the common plan, planned, authorized and approved the illicit coaching of the 14 main case defense witnesses and provided precise instructions which were, in turn, implemented by Mr. Kilolo. Mr. Bemba authorized the illicit payment of money to the witnesses prior to their testimony. Mr. Bemba also spoke with witnesses personally on the phone by abusing the ICC detention center privileged line. Mr. Bemba took measures, as agreed with Mr. Kilolo and Mr. Mangenda, to conceal the common plan, including the exploitation of his privileged line at the ICC detention center and remedial measures upon learning of the Article 70 investigation against them. Mr. Kilolo, as counsel for Mr. Bemba, leading the defense investigation activities, implemented Mr. Bemba's instructions and illicitly coached the 14 main case defense witnesses either over the telephone or in personal meetings in close proximity to the date of the witnesses' testimony. He instructed the witnesses on A, key points bearing on the subject matter of the main case, and B, matters bearing on the credibility of the witnesses, such as their behavior when testifying, their prior contacts with the defense, acquaintance with certain individuals, and payments of money or promises received from the main case defense. Mr. Kilolo illicitly coached, scripted, dictated, and corrected the 14 main case defense witnesses' expected testimonies, also in light of the evidence given by other main case defense witnesses. He, for example, instructed one witness, quote, "Here is what you will tell them," unquote. Quote, "You answer as we agreed, and here you will only repeat and you will only say," etc. Mr. Kilolo dictated to another witness, quote, "Say that you don't know about that. You don't have that exact information. If you give that, it's going to look suspicious. You don't know anything about that," unquote. Mr. Kilolo also told witnesses to lie during their testimony about payments and material benefits, non-monetary promises, prior contacts with the main case defense, and acquaintances with certain individuals. For example, he gave concrete instructions to a witness late at night, quote, "No one called you. No one from the defense called you during the night to prepare you, telling you to be careful tomorrow. Say this and say that. Never, never, never," unquote. Mr. Kilolo's intention to impress upon witnesses what to say in court is further underlined by his tone and language, such as the abundant use and constant repetition of the directives given to another witness, such as, quote, "Don't forget, you must simply stress that, you have to say, you will say, don't say, or stick to," unquote. He also gave concrete directions as how to behave in the courtroom. In one case, he said to the witness, quote, "If they confront you with other things that you and I haven't agreed on, you just find it confusing, you don't know what to answer, just tell them you don't know or that you've forgotten as it was a long time ago," unquote. All of this sought to obscure the impression that the judges of Trial Chamber 3 formed of the witnesses' testimonies. It attempted to impact their ability to properly assess the witnesses' credibility and ultimately establish the truth. To put it straightforwardly, the judges of Trial Chamber 3 may not have followed the testimony of these witnesses, but may essentially have followed Mr. Kilolo's conception of certain aspects of their testimony. It may have been Mr. Kilolo who spoke through the witnesses in the end. Mr. Kilolo kept close contact with all 14 defense witnesses before and during their testimonies, sometimes late at night or early in the morning, so as to make sure that they complied with his instructions. He did so in deliberate disregard of the contact prohibition imposed by Trial Chamber 3 after the defense witnesses had been entrusted into the care of the Victims and Witnesses Unit. Mr. Kilolo rehearsed with the witnesses the prospective questions of the victims' legal representatives, which had been confidentially shared with the main case defense, and did so in the same order they would be put in court and provided the expected replies. Mr. Kilolo also made the calling of witnesses dependent on their willingness to follow his narrative, or on the fact that he had extensively briefed them beforehand. He also intentionally gave, transferred, or facilitated the giving of money, amounts varying between 600 and 800 euros or 1,300 US dollar, material benefits, for example, a laptop, or non-monetary promises, for example, Mr. Bemba's good graces, to witnesses with a view to securing their testimonies in favor of Mr. Bemba in the main case. Mr. Mangenda, whose role in the defense team went beyond that of solely a case manager, advised both Mr. Kilolo and Mr. Bemba on an equal footing and liaised between the two. He also conveyed Mr. Bemba's instructions, assisted and advised Mr. Kilolo on the illicit coaching activities. Mr. Mangenda updated Mr. Kilolo on the testimony of witnesses whenever Mr. Kilolo was not physically present in the courtroom, so that he could effectively and illicitly coach the witnesses in order to streamline the evidence in favor of the main case defense. For instance, when Mr. Kilolo asked Mr. Mangenda whether co-counsel Peter Haynes had blamed him for the bad performance of a witness, Mr. Mangenda replied, quote, "So what does he want? There is a witness who's telling the truth. He should be happy," unquote. Mr. Mangenda also advised on which witnesses performed badly or needed to be instructed, and made proposals on how best to carry out the illicit witness coaching. Mr. Mangenda also provided Mr. Kilolo with the questions of the victims' legal representatives, knowing that Mr. Kilolo would use them to illicitly coach witnesses. He accompanied Mr. Kilolo on field missions, knowing that Mr. Kilolo illicitly coached the witnesses. He also participated in the distribution of cell phones to the main case defense witnesses without the knowledge of the registry, knowing that Mr. Kilolo would use them to remain in contact with the witnesses during their testimony. Mr. Mangenda also took steps as agreed with Mr. Bemba and Mr. Kilolo to conceal the common plan, including remedial measures in light of his discovery of the Article 70 investigation. In achieving their goal, the three accused also relied on others, including the co-accused Mr. Babala and Mr. Arido, who, though not part of the common plan, also made efforts to further this goal. We will return to this. On 11th October 2013, 1 month before the last defense witness was called in the main case, Mr. Mangenda informed Mr. Kilolo, quote, "top secret," that he had received information that an investigation for alleged bribing of witnesses had been initiated against them. Mr. Mangenda explained to Mr. Bemba the possible effect of such investigations. Quote, "That will now destroy all the witnesses we have," unquote. From the time the three accused gained knowledge of an Article 70 investigation against them, a number of remedial measures were conceived and implemented with a view to frustrating the prosecution's investigation. Mr. Bemba instructed Mr. Kilolo to contact all defense witnesses in order to ascertain whether any one of them had leaked information to the prosecution. Mr. Kilolo complied with this instruction. Mr. Bemba, Mr. Kilolo, and Mr. Mangenda agreed to offer defense witnesses incentives and money so that they might terminate their collaboration with the prosecution, and to obtain declarations from the defense witnesses attesting that they had lied to the prosecution. However, the Chamber was unable to establish that Mr. Mangenda's involvement in illicit activities with these witnesses relating to offenses against the administration of justice went beyond that just described. Mr. Babala was in regular telephone contact with Mr. Bemba and was his financier, transferring money at his behest. He intentionally effected a money transfer to the wife of a witness and facilitated the money transfer to another witness's daughter. In the context of those two payments, Mr. Babala advised Mr. Bemba, quote, that it's good to give people sugar, unquote, meaning to bribe witnesses. After Mr. Bemba, Mr. Kilolo, and Mr. Mangenda became aware of the initiation of an Article 70 investigation against them, Mr. Babala discussed possible remedial measures. Mr. Babala encouraged Mr. Kilolo to ensure, quote, le service après-vente, that is to say, paying witnesses after their testimonies before trial chamber 3. However, the chamber was unable to establish that Mr. Babala had any involvement with illicit witness activities related to offenses against the administration of justice other than that already mentioned in respect of the 2 witnesses. Mr. Arrido recruited 4 out of 14 main case defense witnesses and promised them payment of 10 million Central African francs and relocation to Europe. These promises were given by Mr. Arrido as an inducement to procure the testimony of the 4 main case defense witnesses in favor of Mr. Bemba. Indeed, as the witness confirmed, the promised money was their, quote, motivation to testify in the main case. Mr. Arrido acted as a go-between, as one witness has formulated it, and relayed the witnesses' concerns and demands for money and relocation to Mr. Kilolo. Prior to Mr. Kilolo interviewing the 4 witnesses, Mr. Arrido briefed them or facilitated their briefing by others to present themselves as soldiers whilst believing that they did not have such background. He assigned the witnesses their alleged military ranks and handed out military insignia. He also provided details to the witnesses regarding their purported military background, experience, and training. However, the chamber was unable to establish that Mr. Arrido had any further involvement in illicit activities with these witnesses related to offenses against the administration of justice. In light of this, the chamber is convinced beyond reasonable doubt that the accused have committed the following offenses against the administration of justice. The accused, Mr. Bemba, Mr. Kilolo, and Mr. Mangenda, established a common plan to deceive trial chamber 3 in the main case. The evidence clearly shows that they worked together in close coordination to present false evidence to the chamber. The evidence shows that they systematically circumvented every measure implemented by the court to ensure the integrity of the proceedings, such as the handover of the personal telephones of witnesses to the Victims and Witnesses Unit, the Witness Familiarization Protocol, and the VWU cut-off dates for contacts between the witnesses and the calling party. They executed this plan by presenting 14 defense witnesses who were either bribed or made undue promises such as relocation, or were illicitly coached or told to give false evidence. Mr. Babala helped to put into effect the common plan by intentionally effecting or facilitating money transfers in relation to 2 witnesses. Mr. Arrido recruited 4 out of 14 witnesses and promised them money and relocation as a reward for testifying in favor of Mr. Bemba. The chamber will now enter its verdict, directing each accused to stand up in turn. First, please, Mr. Bemba, rise. Mr. Jean-Pierre Bemba Gombo, the chamber finds you guilty under Article 70, paragraph 1, B and C, in conjunction with Article 25, paragraph 3A of the statute, of having corruptly influenced witnesses, D2, D3, D4, D6, D13, D15, D23, D25, D26, D29, D54, D55, D57, and D64, and having presented their false evidence as co-perpetrator, and guilty under Article 70, paragraph 1A, in conjunction with Article 25, paragraph 3B of the statute, of having solicited the giving of false testimony by witnesses D2, D3, D4, D6, D13, D15, D23, D25, D26, D29, D54, D55, D57, and D64. Mr. Bemba, you may be seated. Mr. Kilolo, please rise. Mr. Eme Kilolo Musamba, the chamber finds you guilty under Article 70, paragraph 1, B and C, in conjunction with Article 25, paragraph 3A of the statute, of having corruptly influenced witnesses D2, D3, D4, D6, D13, D15, D23, D25, D26, D29, D54, D55, D57, and D64, and having presented their false evidence as co-perpetrator. And guilty under Article 70, paragraph 1a, in conjunction with Article 25, paragraph 3b of the statute, of having induced the giving of false testimony by witnesses D2, D3, D4, D6, D13, D15, D23, D25, D26, D29, D54, D55, D57, and D64. Mr. Kilolo, you may be seated. Mr. Mangenda, please rise. Mr. Jean-Jacques Mangenda Kabongo, the Chamber finds you guilty under Article 70, paragraph 1b and c, in conjunction with Article 25, paragraph 3b, paragraph 3a of the statute, of having corruptly influenced witnesses D2, D3, D4, D6, D13, D15, D23, D25, D26, D29, D54, D55, D57, and D64, and having presented their false evidence as co-perpetrator. And guilty under Article 71, paragraph 1a, in conjunction with Article 25, paragraph 3c of the statute, of having aided in the giving of false testimony by witnesses D15 and D54, and abetted in the giving of false testimony by witnesses D2, D3, D4, D6, D13, D25, and D29, and not guilty under Article 70, paragraph 1a, in conjunction with Article 25, paragraph 3c of the statute, of having aided, abetted, or otherwise assisted in the giving of false testimony by witnesses D23, D26, D55, D57, or D64, and acquits you of the charge in respect to those factual allegations. Mr. Mangenda, you may be seated. Mr. Babala, please rise. Mr. Fidel Babala Wandu, the Chamber finds you guilty under Article 70, paragraph 1c, in conjunction with Article 25, paragraph 3c of the statute, of having aided in the commission by Mr. Bemba, Mr. Kilolo, and Mr. Mangenda of the offense of corruptly influencing witnesses D57 and D64. Not guilty under Article 70, paragraph 1a and b, in conjunction with Article 25, paragraph 3c of the statute, of having aided, abetted, or otherwise assisted in the commission by Mr. Bemba, Mr. Kilolo, and Mr. Mangenda of the offences of giving false testimony by witnesses D2, D3, D4, D6, D13, D15, D23, D25, D26, D29, D54, D55, D57, and D64, and presenting their false evidence, and acquits you of those charges. And not guilty under Article 70, paragraph 1c, in conjunction with Article 25, paragraph 3c of the statute, of having aided, abetted, or otherwise assisted in the commission by Mr. Bemba, Mr. Kilolo, and Mr. Mangenda of the offences of corruptly influencing witnesses D2, D3, D4, D6, D13, D15, D23, D25, D26, D29, D54, and D55, and acquits you of the charge in respect of those factual allegations. You may be seated, Mr. Babala. Mr. Arrido, please rise. Mr. Narcís Arrido, the Chamber finds you guilty under Article 70, paragraph 1c, in conjunction with Article 25, paragraph 3a of the statute, of having corruptly influenced witnesses D2, D3, D4, and D6. And not guilty under Article 70, paragraph 1a and b, in conjunction with Article 25, paragraph 3c of the statute, of having aided, abetted, or otherwise assisted the commission by Mr. Bemba, Mr. Kilolo, and Mr. Mangenda of the offence of presenting false evidence of witnesses D2, D3, D4, and D6, and of having aided, abetted, or otherwise assisted in the commission of D2, D3, D4, and D6 of the offence of giving false testimony, and acquits you of those charges. Mr. Arrido, you may be seated. Please allow me some closing remarks. This case was evidently not about judging the defense before the court in general. It was evidently not about criminalizing legitimate defense strategies. This case was also not about a gray area in law pertaining to defense behavior. And it was not about special difficulties that the defense in international criminal cases faces. Rather, it was about clear and downright criminal behavior of the 5 accused. Mr. Bemba in the position of accused before trial chamber 3, Mr. Kilolo and Mr. Mangenda as members of his defense team. It was about criminal behavior that resulted in serious offenses against the administration of justice. It was about an abuse by a few members of a defense team as a party to the proceedings of their position. It was done in favor of and with the participation of their client and also with the help of others. No legal system in the world can accept the bribing of witnesses, the inducement of witnesses to lie, or the illicit coaching of witnesses, nor can the International Criminal Court. Today's judgment sends the clear message that the court is not willing to allow its proceedings to be hampered or destroyed. It sends the message that those who try to distort and interfere with the administration of justice of this court do not go unpunished. Mr. Prosecutor, we were given to understand, Mr. Van der Poel, exactly following your communication from this week, that you may have an application to make. Just a yes or no answer for the moment, please.
Yes, Mr. President.
Yeah. In view of this answer, the Chamber will take a short break and then reconvene to hear submissions on this new request. Please stay in the courtroom or close by so that we can reconvene quickly.
All rise. We will wait.